Hello, everyone, and welcome to Uncivil Law. And today we have a decision from the Supreme Court of Pennsylvania dealing with the constitutionality of the Pennsylvania governor's COVID-related orders. This is the decision of Tom Wolf versus Scarnati. In this case, the legislature tried to pass a resolution that ended the governor's authority to do certain stuff under COVID. And the Supreme Court of Pennsylvania has analyzed what the legislature did and tried to figure out whether or not it's legal under Pennsylvania law. So we're going to read this decision and try to figure out whether or not what the legislature did was constitutional. Let's get started with this. Our government's response to the challenges presented by the COVID-19 pandemic, and by our government, we mean Pennsylvania because this is a Pennsylvania decision, has engendered passionate arguments that span the political spectrum. That's one way of putting it. Pennsylvanians have watched with great interest as the political branches of Pennsylvania, represented by the governor and the General Assembly, have debated how best to respond to this disease. We here, however, are only here on a very narrow legal question. So this is a very narrow question. What is the exact question we're trying to answer? That's a good place to start. The question we're trying to solve is whether the Pennsylvania Constitution and the Emergency Services Management Code permit the General Assembly to terminate the governor's proclamation of a disaster by passing a concurrent resolution without presenting that resolution to the governor for his approval or veto. Okay, so just to take note where we are, we're not trying to decide whether or not what the governor did was constitutional. That would be decided in part by the federal court most recently. We covered that on a very long stream about whether or not those actions were constitutional. We're not here trying to solve that question. We're here trying to solve a different question. The legislature is trying to stop the governor, and they're trying to do it by passing a concurrent resolution. But they didn't present it to the governor for his signature or veto. They just passed a resolution that said, please stop. So the question is, very specifically, is that constitutional? Can the legislature just pass a please stop and it become effective? All right, so let's try to figure that out. On June the 3rd, 2020, the governor renewed his emergency proclamation for an additional 90 days after it had already expired, and he renewed it. And then on June the 9th, 6 days later, the legislature of Pennsylvania, the Senate, and the House of Representatives adopted a concurrent resolution ordering the governor to terminate the disaster emergency. So the governor said, I'd like to extend. And the legislature said, how about no? And so then they passed a resolution saying that, and yeah. This dispute, therefore, concerns whether this concurrent resolution is subject to presentment, requirement, embodiment in the Pennsylvania Constitution. So, like the federal system and like pretty much every state to the best of my knowledge, if you want to pass a law, you need the legislature to pass it and the governor to sign it and then override the veto if necessary. And that's called presentment, presenting it to the governor. So this concurrent resolution, do you have to present it to the governor? So in common parlance, that would mean it would be subject to the governor's veto power. Yes, it would. So here's what our Constitution, the Pennsylvania Constitution provides. Here's what it says. Always going back to the plain text, always a good place to start. So what does the Pennsylvania Constitution say? It says, every order, resolution, or vote to which the concurrence of both houses may be necessary, except on a question of adjournment, shall be presented to the governor, and before it shall take effect, shall be approved, or being disapproved, shall be repassed by 2/3 according to rules and limitations prescribed in the case of a bill, which is pretty much the same as the federal system. So if you need both houses, it has to be presented to the governor/president. It has to be signed. If not, you have to do a veto override. Pretty much the same thing as the federal system. Okay. And then the Pennsylvania Supreme Court says our Constitution is clear. All concurrent resolutions, except in narrow circumstances, must be presented for approval or veto. That does seem the language. To allow a concurrent resolution that does not fit into one of these exceptions to take place would be to authorize a legislative veto, which is not what our Constitution allows for, even if it could be allowed by a different Constitution. The senators here contend that the resolution that they passed fit into one of the exemptions. So they say this is exempt from that requirement. All right, so we're going to try to figure out whether or not it's exempt from the requirements for presentment. So there are 3 exemptions that apply in Pennsylvania. The first exemption is obvious from the text itself. So there is an exception for a question of adjournment. So if the legislature wants to not be in session, that's not signed by the governor. Great. So, but no party offers that this is what that is. This isn't in order to adjourn the Congress. And incidentally, that doesn't need approval from the president either in the federal system. So one thing we can do is like not be in session anymore. Don't need the governor's approval for that, but it's right in the text of the thing. So no problem. All right. So the second one is a proposal that would put in place a constitutional amendment. And the Constitution itself of Pennsylvania also authorizes this for amendments of the document, which incidentally, once again, is the same thing for the federal system. So yeah, for a bill to become law, generally speaking, it has to be passed by Congress and signed by the president, and if not, vetoed. But constitutional amendments are not bills, they're constitutional amendments. So both in the federal system and the state system, they don't need the signature of the governor or the president. The president plays no part in the constitutional amendment process. He is not part of the equation. In the federal system, you need 2/3 of each house and 3/4 of the states. In the Pennsylvania system is presumably somewhat similar to this. And much like the federal system, in the state system, the governor has absolutely no part. So the concurrent resolution is how you do this. And the reason you know that is because the section that describes how to make amendments tells you. So there's a section that says every bill that needs both houses needs the signature of a governor. And then there's a different section that says in the case of amendments, not so much. So the more specific overrules the general. It's one of your conflicts of laws rules. The specific overturns the general. So you have a law that says, in general, you need to do this, and then says, in specific, you don't. How do you know which one governs? Well, the more specific overcomes the general. That's how you do that. So it says, yeah, you don't need the governor's signature for that. No problem. Okay, great. So is this a constitutional amendment? No, it's obviously not. All right, so what else? The third exception to presentment is not explicitly listed in our Constitution, but rather is inherent in the structure of our charter, which is pretty much the same thing in the federal system. There's also this exact same exception. The presentment exception only applies to matters that govern constitutional provisions concerning legislative power. In other words, it's perfectly manifest that orders, resolutions, and votes must be submitted to the governor and only can be as part of the business of legislation. Although no provision of the Constitution explicitly withdraws non-legislative matters, such resolutions only affect the internal affairs of the legislature. Under the separation of powers of government, no branch should exercise the functions exclusively committed to another branch. Pretty much the same thing in the federal system too. The legislature, a co-equal branch of government, has sole authority to determine its rules of its proceedings. So yeah, both in the federal system and in the state system of Pennsylvania, if it's purely internal, you don't need the signature of the governor because that would be dumb. Because it's purely internal for the legislature to determine its own rules. So yeah, even though the Constitution doesn't explicitly say it, it is in the structure. It's in the structural construction of the thing. It's a derived principle. So, we have a separate legislative, executive, and judicial. And so what you're doing is within the four corners of legislative, then you don't need anyone else's permission because it's within the four corners. So if you want to pass a resolution just dealing with yourselves, no problem. If you want to pass a resolution dealing with your rules, no problem. If you want to pass a rule dealing with access to the legislative building, probably that's totally cool too. Incidentally, also the same thing for the federal system. So if the federal government wants to have someone lie in state at the Capitol, for example, you need a bill passed, but it's just a concurrent resolution. It doesn't have to be signed by the president. So if you want someone to lie in state, you just need the House and Senate to pass a resolution and no problem. Why? Because it's wholly within the bounds of the legislative building. It affects nothing except the internal processes. If you want to assign people office spaces or whatever, that's cool, no problem. So as long as you're within the four corners of just dealing within your own domain, no problem. So the question here is, are we within the bounds of just legislative, or is this outside that bounds? So the legislature wants to say, oh, this is just within the bounds of the legislative. This is internal. Resolutions that are investigatory, for impeachment, for example, or ceremonial, it would be, we want to say things about people just generally, although not technically procedural, are still within the province of the legislature. Yeah. And need not be presented, as such resolutions are not legislation. Yeah. Same thing in the federal system. We want to start an investigation. Okay, great. We want to honor somebody. Well, strictly speaking, not procedural, but it affects literally no one, and it's just you saying stuff, so whatever, we don't care. So as the governor notes in Russ versus Commonwealth, the court has explained the difference between resolutions that are internal and those that are not. Do it exceed the bounds of the chamber? In distinguishing between the resolutions that are internal and those that are not, the Supreme Court of Pennsylvania has written, if both houses had simply resolved to attend the exercises in a body and to adjourn the day, it would be no concern of the governor and could go without his approval. But if it was embodied in the resolution amounting to practice of enactment of authority to act on behalf of the state in making recognition, that would be something that the governor would have to approve of because it exceeds the four walls of the legislative branch. Thus, where the legislature seeks to act on behalf of the state by way of concurrent resolution, that resolution must be presented to the governor. Pretty much the same thing as the federal rules too. The Attorney General of Pennsylvania has noted that When this court has to determine whether a concurrent resolution is legislating, the court must look to the substance of it and not what it's called. Yeah, no joke. Just what you put on the label may not be what's inside the bottle. So as is very typical in law, we very rarely look to what the label is. We look to what it is. So what you call it is super duper interesting and all, but it may not actually be that thing. So you've called it a concurring resolution, but let's look to what's actually in the bottle. All right. As the governor has noted, when the Federal Constitutional Convention added a provision analogous to this, James Madison said, if the negative of the president were codified to bills, it would be invaded by such acts and forms of resolutions, votes, etc. So James Madison also saw this problem. So if we said, well, the president has to approve bills, the legislature could say, this isn't a bill. This is a resolution. This is a vote. This isn't a bill. So no, we're not that dumb. We're going to look to what it actually is, not what you put on the label, because we're not stupid. The senators do not dispute that resolutions with legal effect should be subject to presentment. Rather, the senators contend that neither the governor's proclamation nor this thing have a legal effect, and therefore it should not be subject to presentment. Okay, that's an interesting argument. So the governor, when he issued this proclamation, that has no legal effect. And when we wrote this resolution, that had no legal effect. If it has no legal effect, why are we doing it would be a reasonable question. And the governor's order isn't illegal. It doesn't have legal effect. Well, I don't know, man. People have been confined to homes and businesses have been shut down. Seems like it has some legal effects, but let's give that a try. Let's give neither the proclamation nor this thing or have legal effects. Looking first to the proclamation, it's obvious the order has legal effects. The proclamation, for example, transferred funds, suspended certain statutory and regulatory provisions, and activated the National Guard. The senators, being ever creative, tried to claim that this proclamation was merely a declaration of fact, and did not and could not prescribe the rules of civil conduct, and instead established a factual predicate necessary for other executive agencies to use certain powers granted them by statute. Emergency proclamations, they argue, are not laws, but rather formal announcements that create the circumstances necessary for the exercise of certain powers. Setting aside the proclamation's direct legal effects, to distinguish between the governor authorizing other agencies to act and those other agencies taking actions pursuant to the proclamation would elevate form over substance. Trying to say there's a difference between the governor issuing the directive and then the consequences of those directive seems like a little bit like you're just trying to put different labels on the same thing. Not so much for you. The proclamation authorized other agencies to act, and those agencies could not have issued those orders, such as requiring the closures of business, if it had no legal effect. If nothing else, the legal effect of the proclamation was to allow the governor to exercise powers granted him upon the declaration. The proclamation had actual effects that are legally significant. Amazing. Deep. Yeah, so that doesn't make any sense. All right, so let's give argument number 2 a shot. The resolution doesn't have a legal effect. Why are we doing it then? I don't know, but it doesn't have legal effect, say these senators. Okay, let's give that a shot. Turning to this resolution, the senators argue that it does not provide for the expenditure of funds and does not commit the state to perform an affirmative act. It's not of a legal nature because it doesn't cause us to spend money and doesn't require the state to do stuff. The General Assembly can pass a bill or resolution that has a legal effect even if the bill does not commit to the spending of money. Just because we're not spending money doesn't mean that it doesn't have a legal effect. Spending money is definitely something the legislature can do, but they can also do something that doesn't have the expenditure of money involved. For example, every time they add a crime to the criminal code, that conduct becomes illegal, even though it does not in and of itself cause us to spend money. That seems legally operative, even though money isn't being spent as such. Yeah. One could not argue the General Assembly could amend the criminal code through a bill or resolution without presentment simply because it did not appropriate funds. If to do legislative thing means to spend money, that would mean the legislature can create crimes out of thin air without presentment because most of the time they're not spending money. Supreme Court of Pennsylvania says, no, I think the legislature can do stuff other than by spending money. Effectively acknowledging this non-expenditure-based category of legislative matters, which, the senators offer this. Okay, so let's give this a try. Because the resolution does not authorize any action on behalf of the state, it is not a legislative action. It doesn't require the state to do stuff. They say it doesn't require the state to do stuff. Although in Russ we noted that a resolution authorizing the General Assembly to act on behalf of the state would require a presentment. Yeah, so their argument is it doesn't require the state to do anything. In a prior case called West Shore, we considered whether the General Assembly could use a concurrent resolution without presentment to reestablish the Pennsylvania Labor Relations Board after the agency was slated to be disbanded. We ruled that mere passage of a resolution reestablishing an agency would be something that requires the state to do something, namely keeping the agency intact. We're not requiring the state to do anything because the agency was already there, but it was slated to be not there, and you're requiring it to continue to be there. That would require the state to do stuff, even if it's the stuff they were doing about 5 seconds ago. They were planning on not doing it, and you're ordering them to do it. That is an order to do stuff. So this resolution acts in the same manner as that resolution and the above hypothetical. So even if senators are correct that the resolution does not require any affirmative act on the behalf of the governor, which, the same was true in the prior case. There, the concurrent resolution did not require the executive branch to act. It simply mandated the executive branch not allow the thing to terminate. Prohibiting termination has a legal effect. Even if it doesn't require the governor to do something somehow, it has a legal impact, namely the labor board is still there and the labor board is doing stuff. So that kind of has a legal impact, yes. As the amici in this case observed, the resolution would dramatically alter the enforcement and suspension of certain state laws and regulations. So as to the idea that this is not going to cause things to happen, the amici disagree. They think it will cause lots of things to happen. Economic activity across a wide range of sectors, medical and healthcare, public health operations, National Guard deployment, and other aspects of lives for everyday millions of Pennsylvanians. It's going to have a little bit of effect in the law, yeah. Enforcement of this resolution, which requires the governor to end the state of emergency, which incidentally is requiring the state to do stuff, would have far-reaching legal consequences beside him simply signing and publishing a new proclamation. Yeah, it's not just that the governor has to sign and publish something. If the governor does that, it's going to have ripple-on effects because proclamations have meaning. It would prohibit the governor from taking actions, and prohibition itself is a legal effect. Of course it is. To distinguish between a resolution that requires the governor to do stuff and a resolution that forbids him from doing stuff would be elevating form over substance. Yeah, there's not a lot of difference in saying, governor, you must do, and governor, you shall not do. Not a lot of difference, both of which you're impacting the governor and has legal operative effect. No joke. So what you put on the label doesn't matter. I agree. The dissent in this case, which apparently is a thing that exists, offers a novel view of our Constitution and our precedent. Okay. The dissent posits this court should use a functionalist approach in determining whether a legislative veto passes constitutional muster. Relevant to this case, the dissent suggests the breadth of essential delegation of emergency powers to the executive in light of future and unforeseen circumstances justifies an equally extraordinary veto power in the legislature. Wow. That's deep. Okay, so the dissent here wants to say because the powers of the governor are really, really expansive, that means that the legislature should have something equivalent to that. They should have some sort of comparative power because of this amazing power the governor has. I wonder who it might have been who gave the governor this power in the first place. Who might it have been who decided that it would be a good idea for the governor to have this amazing power? If only we could consult the body that said, hey, it'd be great for the governor to have all this massive authority. If only we could find that group of people. In sum, there is no support in this Constitution or decisions for the proposition that cumbersomeness and delays are often encountered in complying with explicit standards may be avoided by characterizing the legislation as a delegation of emergency powers. No, a legislative veto might be a good idea, it might be a bad idea, but it's constitutionally invalid under our Constitution. Our conclusion that the concurrent resolution seeking the force of the governor to end the state of emergency has legal effect and does not fit in any of the exceptions bears on the interpretation of the statute itself. Okay, so there's a statute that says some stuff. So now we got to interpret the statute. So that's always a good idea. So we've interpreted the Constitution already. So let's interpret the statute and figure out if it's inconsistent. Good place to start. Also, so here's what the resolution provides. The General Assembly, by concurrent resolution, may terminate a state of disaster at any time. Thereupon, the governor shall issue an executive order or proclamation ending the disaster emergency. So there's a law that says the General Assembly can terminate this by concurrent resolution, and then the governor shall do some stuff. Okay, that seems pretty promising. Let's go interpret that language. Thus, when we evaluate the plain text of the statute, expresses the General Assembly's intent that presentment not be part of it. So does the statute say, or does it require that the presentment not be part of it? It says there's a concurrent resolution, and then it says governor do something, is presentment excluded. All right, so the senators say, and their amici say, that this section cannot be read to require presentment. They're providing a little textual analysis. The senators point to the words at any time, thereupon, and shall issue to suggest the General Assembly did not intend to require presentment for this particular kind of concurrent resolution. Okay, so we have an idea here. We have an idea that there's a statute, the statute that gives the governor the authority to do all this stuff. So that statute that allows the governor to do all this stuff has this clause. And this clause says, upon a concurrent resolution, then the state of emergency shall end, and that will be the end of that. So does that provision itself require presentment? It doesn't say it. It doesn't say either way. It doesn't say without presentment, doesn't say with presentment. It's a little bit silent on the issue. And they point to the language that says, well, it says, once we do this, this shall happen, and seems with effect automatically. Okay, so is that what it says? All right, so let's give that a shot. We acknowledge that this reading is reasonable. It's very reasonable. It seems like automatic on its face. We acknowledge that the senator's reading of this section is reasonable. It is reasonable on its face because the language doesn't require it on its own terms. In particular, the word thereupon could imply the governor must issue this order as soon as the General Assembly passes the resolution, without the governor having the opportunity to approve or veto the legislation first. However, the senator's interpretation of the statute is not the only reasonable reading. The statute does not on its own terms unequivocally state the declaration is terminated the moment it passes the resolution purporting to do so. If the General Assembly intended to give itself the ability to terminate the state of disaster unilaterally, there would be no need to involve the governor in this equation at all. The governor is mentioned in the language, so there's that. If it had been the intent of the General Assembly, the language could have been considerably more straightforward and truncated. The state of disaster emergency will be terminated by passage of concurrent resolution so stating. Instead, the General Assembly chose to require an extra step. The governor must terminate the state of the emergency. The requirement that the governor must act is a sign the General Assembly understood its concurrent resolution would be presented to the governor. So they say, well, there's this language here that seems to suggest that that's a thing. As we've explained in this case, Friends of Danley DeVito, the broad powers granted the governor in the emergency statement code are firmly granted in the Commonwealth's police power, which is the general power to do stuff. The General Assembly has the power to terminate a declaration of disaster emergency without any action by the governor, aside from presentment and overriding the event of a veto. If the legislature wishes to end the disaster emergency and satisfies presentment, followed by either governor's approval or veto override, then further action by the governor would be in any event necessary. So the legislature can do this without the governor. They just need to do a veto override. If a statute or resolution is passed over the governor's veto, the governor must still abide by the law. So if the legislature overrides his veto, the governor is bound by it just as surely as if he signed it, which makes sense. As for another reason to interpret the statute this way, under the canon of constitutional avoidance, if a statute can be read one of two ways, one of which would raise difficulties and one of which will not, we adapt the layer construction. So this language that says, upon the concurrent resolution, the governor shall do some stuff. It doesn't say that needs to be presented to the governor. And the senators say, look, the most natural reading of this is that it shouldn't be applied to the governor. And the Supreme Court of Pennsylvania is saying here a very common doctrine. It's constitutional avoidance. It says, well, that is the Supreme Court isn't actually saying this in so many words, but they're implying it. The Supreme Court of Pennsylvania is essentially implying that is the most natural reading of it. The most natural reading of it is that there shouldn't be presentment. But we're going to interpret it the other way. The reason we're going to interpret it the other way is for a very, very easy reason. We're trying to avoid a constitutional problem. If we interpreted it as not requiring presentment, the statute would be unconstitutional. So we're trying to interpret it in a constitutional way because our Constitution requires presentment. So the statute itself is silent. It probably is most naturally read as not requiring presentment. But if we read it that way, it'd be unconstitutional anyway. So we're going to read it in a constitutional way, which is that it requires presentment. So even though the statute doesn't say it and somewhat implies against it, in order to avoid the constitutional problem, we're going to interpret the other way. This is very, very common for courts to do. So we're going to give it the interpretation that solves the problem. Yeah, okay. So if we can do it, we will do it. We can do it here. It doesn't say it explicitly otherwise, so we'll read it in because it's the status quo, and we'll assume that they knew about it. And yeah, okay, let's give that. So that's one way to solve this problem. It makes sense. Applying this canon of constitutional avoidance, the law must be read to require presentment to the governor. As discussed above, any resolution seeking to end the declaration has the effect of legislating, which needs presentment. Thus, although the interpretation is reasonable on its face, that interpretation would violate our Constitution, so we're not going to do that. Because there's another reasonable interpretation, we'll read it that way. So even though they probably have the better end of it, if we read it that way, it'd be unconstitutional, and so the whole thing doesn't make any sense, and so we'll interpret it the other way. So it's constitutional, and yeah. Both the governors and senators point to precedent from this court where we have and have not applied this this avoidance provision, interpreting a provision that not explicitly require it. So yeah, sometimes you do this and sometimes not. For example, in Sessoms, we conclude the General Assembly intended to require presentment in a statute, providing the General Assembly could reject sentencing guidelines adopted by the Pennsylvania Commission on Sentencing. Conversely, in the case of West Shore, we determined it could not interpret the provision to require presentment. Thus, we've reached different conclusions in these cases on questions of avoidance, which every legal practitioner knows to be true. So this just confirms what everyone knows to be true. Every case and every statute must be interpreted independently. So sometimes we do it and sometimes we don't. That's because everything has to be interpreted independently, and everyone knows that. Of course so. Evaluating the statute, we find there are two reasonable interpretations, and thus we must apply our canon of constitutional avoidance as to weigh them. While the canon of constitutional avoidance leads us to interpretation we adopt here, the reading of the statute in its entirety further militates in favor of presentment. In the clearest language possible, the statute authorizes the governor to declare an emergency has occurred or is imminent, to continue the state of emergency until such time as the governor finds the threat or danger has passed, and to the extent the threat has passed or the emergency no longer exists, to terminate the state of disaster by executive order or proclamation. Thus, while the statute presents that the General Assembly may terminate a disaster emergency at any time, the statute also provides the state of emergency ends only after the governor so finds. Based upon the plain text of the statute and on our own canon counseling against invalidation of statutes on constitutional grounds wherever possible, we hold the provision to terminate by concurrent resolution requires presentment of that resolution to the governor. As an alternative argument, however, the senators posit the General Assembly could end the state of emergency via concurrent resolution without presentment, that under a different clause of the Constitution. So they say there's a different clause of the Constitution that we can try. So there's the clause that says, no power of suspending the law shall be exercised unless by the legislature or by its authority. First, they maintain the provision gives the right to the legislature to suspend unilaterally, essentially asking this court to recognize a new exception to presentment. Second, the senators contend the governor's power under the section were a delegation of the suspension power, and the court should permit the General Assembly to revoke its authority without permission. So they say there's another provision that says you can't suspend the laws unless the legislature allows for it, and so that might give some different authority. So let's give that a try. The history of the clause indicates the clause was intended as a negative check on executive power, rather than as an affirmative grant on the power of the legislature to act unilaterally. The senators attempt to call our attention to a suspension clause in the Louisiana Constitution, yet the corresponding clause in that Constitution is fundamentally different than our own. The Louisiana Constitution expressly exempts the suspension of laws from the governor's veto. Presentment is not required under its Constitution, unlike ours. Based upon the original history of Article 1, Section 12, the framers' decision to place that provision in our Declaration of Rights, a comparison of the statutes with other presentment and the practice of other jurisdictions, we hold that this section does not affirmatively grant the General Assembly the power to suspend laws unilaterally. Finally, the senators allege a violation of the non-delegation doctrine. In their initial brief, the senators offer that because the proclamation itself was a suspension of law, the General Assembly only reinstated the law. In their self-styled reply brief, the senators argue for the first time that the Emergency Management Code itself is unconstitutional under the non-delegation doctrine. So they say, well, this law that we passed is unconstitutional, which is a nice little trick. The senators' initial argument is puzzling. They offer that the non-delegation doctrine only kicks in if the governor is correct in believing that the proclamation is law. Neat. The senators confuse an order having an effect of law with one that exercises legislative power. The non-delegation doctrine forbids entities other from the legislative branch from exercising legislative power, as those entities do not have the power to make a law. So this isn't making a law. This is enforcing a law, and that's different. The governor does not argue that the proclamation he issued is law in and of itself, but rather it has the force of law, which is what happens when the executive does stuff. The proclamation isn't law, but rather it has the force of law, and it has the force of law because the legislature says it does. That may seem like a semantic difference, but it's not. It's really not. No. Executive orders that have individual effects outside the executive branch implement the law. But an executive order or administrative regulation promulgated by an executive agency that implements it has the force of law. Otherwise, no entity outside the executive branch could be compelled to abide a regulation because it wouldn't have the force of law. So, of course, it does have law. It's not law. It has force of law. And it's force of law because the law says it does. Yeah, it's not law unto itself. It's just enactment of a law that you guys passed. Brilliant. If we did that, that result would be inconsistent with long-standing precedent and also just the nature of what executive and legislative means. Yeah. The General Assembly, in enacting the statute, makes the best policy choices. The General Assembly decided that the governor should be able to exercise certain powers when he or she makes a finding that disaster has occurred or occurrence of the threat of disaster is imminent. General Assembly is the one who decided this was a great idea. Go and blame yourselves on that one. This is just the Spider-Man pointing at each other meme at this point, because the state legislature, why does the executive have all this power? Because you're the ones who said he should, you jerks. Additionally, the General Assembly has provided adequate standards which will guide and restrain the powers. The General Assembly gave the governor specific guidance about what he can and cannot do in response to the disaster. The powers delegated to the governor are admittedly far-reaching, but are nonetheless specific. Yeah, just because it's broad doesn't mean it's vague. Broad is not vague. These are really broad powers, but they're pretty specific. So you're the legislature, are the one who decided this was a great idea. In many cases, it may be that more expansive the emergency, the more encompassing the suspension of regulations. But this shows the scope of the emergency, not arbitrary discretion, determines the extent of the powers. In their distinct non-delegation argument with respect to the suspension of laws, the senators contend that when the governor suspends laws pursuant to the delegation of authority, he acts as the legislature's agent and thus is subject to any restrictions the General Assembly can put in place, or doesn't. The same, however, could be said of the governor's power to issue regulations when that power is delegated from the legislative branch. Maybe try not getting the executive to do your work would be a good plan. In this instance, a governor is acting as an agent of the legislature, subject to the constraints of the statute that the legislature himself passed. The legislature said, here's some powers you can have if you find this stuff. He said, I find this stuff, and then have powers. And the legislature's like, wait, what? Who wrote this then? Oh, that's right, it was you. The senator's argument implies the court should create a heightened standard for non-delegation when the delegated power is to suspend a law, as opposed to issuing regulations with force of law, which doesn't make sense. When the governor issues regulations that force of law, that has positive effect. If it has negative effect, then so be it. Why would it be different under one way or another? Whose fault is this again? Legislature's fault. Try better next time. The senators may be frustrated that the General Assembly, previously having delegated this power to the governor, brilliant, the rescission of the power requiring presentment, perhaps necessitating the two-thirds majority to override a veto. But the potential for this frustration inheres whenever the legislative branch delegates power to the executive branch in any context. Hey, legislative, you remember how you decided giving power to the executive was a good idea? You're frustrated now that the executive is using the power you delegated to them. You know what might be a good idea? How about if you didn't do that? How about if you just legislated yourself? But no, you're the ones who decided this was a good idea, and now you're frustrated because you gave power to someone and they're using the power in a way that you don't like. Wow, amazing, deep. So maybe, here's an idea, just don't give them the power in the first place and then you won't be disappointed. The General Assembly's attempt through its regulation to overturn the proclamation of disaster without presentment violating the law. As an act with legislative effect, this, like any other concurrent resolution, requires presentment, a key component of our constitutional balance of powers. A balance that prevents one branch of power from dominating the others unless one branch gives all the power to the other, in which case it's kind of your fault. Anytime you want to repeal those laws would be just fine, by the way. The fact that repealing laws requires them to sign off on it, or two-thirds, might have been something you could have considered when you passed the law in the first place. But, you can do that. Thus, because the General Assembly intended that the law terminate the governor's declaration, without presentment, we hold it to legal nullity because, Thus, that brings us to the end of the discussion of Tom Wolfe versus Carnati. In this case, the legislature said, hey, governor, you like to execute laws, right? Well, if you find this stuff, you can execute this power. And then the governor said, I find this stuff, and then execute this power. And then the legislature said, that's not fair. We don't want to do that anymore. And the Supreme Court of Pennsylvania says, whose fault is this now? Whose fault is this? It is your fault. So, no, you can't terminate it just with a concurring resolution because, no, it has actual effect. It has actual legal effect, and no, you can't do that. And the governor can do it because it's law, because you're the ones who said it. You through enactment and presentment created a situation where the governor wants to execute laws. And now you want to, without presentment, stop him. No, not so much. So maybe try to make better laws next time. But in any case, that is the end of our discussion of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.